I think it's just about to start. So, hello and welcome everyone. Wish you a wonderful day. Um, Welcome to Vestralex free online community classes on law. We're grateful for this opportunity to keep learning from the best minds, the best legal minds in the country. And today we have with us Honorable Mr. Justice Shri A.K. Ganguly, former Judge Supreme Court of India. Before I hand over the class to Sir on this very important topic of the art of brevity, a brief introduction about Sir. Uh, Shri Justice Ganguly was born on 3rd of February 1947. He graduated with a Masters of Arts in English from University of Calcutta in 1968 and then received a Bachelor of Laws from the same university in 1970. He started his career in 1969 by teaching at the Kidarpore Academy, a school of which he was once a student. In 1972, he started practice in Calcutta High Court. On 10th of January 1994, he was appointed a permanent judge of Calcutta High Court. He stayed as judge at Patna High Court for more than 6 years and was later transferred back to Calcutta High Court on 1st of August. He subsequently became the senior most puissant judge over there, and he functioned twice as the acting Chief Justice of Calcutta High Court. Later, in March 2007, he took oath as Chief Justice of Orissa. He joined the Madras High Court as Chief Justice on 19th of May 2008. He was eventually elevated to the Supreme Court of India, where he joined on 17th of December 2008 and remained as Judge of the Honorable Supreme Court of India for more than 3 years. Sir retired on 3rd of February 2012. Post his retirement, Sir has worked as guest faculty at National University of Judicial Sciences, Kolkata. He also went on to be the chairperson of West Bengal Human Rights Commission, where his role was highly appreciated. A few noteworthy cases are the 2G spectrum case, the suspension, erroneous suspension of fundamental rights during the emergency, and the president's power to pardon, among various other cases. So, sir, it's a privilege, sir. We most humbly are grateful to have this opportunity to learn from you, and sir, we're just grateful to you for um, uh, your kind, your so self, so that you're always so contributory and you always take the time out to help young lawyers, law students learn, grow, and develop. And so I welcome you on behalf of everyone. And so I hand over the class to you and I request you to kindly take us through this very unique topic of brevity, the art of brevity.
Thank you, Mr. Keshavji, and I welcome everybody, the listeners, to this talk on the art of brevity, and I'm very happy and I feel honored and privileged that I am able to address the study circle of the university or the law students. Now, on starting on the art of talking on the art of brevity, I must confess that I cannot be too long while telling you about the virtues of the art of brevity. I can tell you of my own little experience before I go into this thing more objectively. That as a judge for about 18 years, I have often experienced the boredom of prolix addresses by lawyers. I can tell you, the young budding lawyers, the prolix addresses, repetitive, emphasis on what you are going to say or argue does not improve your case. On the other hand, it produces a sense of boredom on the listeners, namely the judges. And as a result whereof, the judges tend to lose track of your argument. So, my advice to young lawyers and also the enterprising public speakers, the art of brevity is something which you must, if I may say so, must master, must acquire that art before you can hope to make an impression on your listeners. It is called the art of brevity. Since it is called an art of brevity, you must admit that it does not come to human mind very naturally. Naturally, a person cannot be brief and at the same time, he can cover all the aspects of what he's going to say. He can brief, but at the same time, he can be scanty. You can be brief, but at the same time, your speech may be consisting of a few stray sentences. Brevity does not mean that. Brevity means you have to be precise, concise, at the same time coherent. Coherence and precision must combine to make it a brief but an effective presentation. So, therefore, to develop the art of brevity, what is required as the development of every art, it calls for training and it calls for practice. Training means you can be your own trainer. You can learn it from a speaker who is extremely brief, at the same time very forceful. But the point is this: in order to be master the art of brevity, you see, this came from a Shakespearean phrase where he says that brevity is the soul of wit. Now, wit means wisdom. Wisdom is that residue of knowledge which is filtered. First, we get information, then you translate into knowledge, and the last phase of this is wisdom. The experience and the learning which you gain from knowledge is wisdom, and wit means that. So, brevity is the soul of wit. A person who has wit is always brief and to the point. So, what I'm just telling you, it is important to have a mental preparedness, a mental training. So, there are four stages before you can be really master the art of brevity. First, you must know the subject on which you are going to address, on which your speech is best. Therefore, knowledge, intimate knowledge of the subject is most important. If you do not know, you will be beating around the bush. You do not know what you are going to speak. If you have no control over the subject, then you cannot be brief. In that case, you lose the art of brevity. First, an in-depth knowledge of the subject on which you are going to speak. The second is your ability to think clearly. What is the area of your subject? What are the ingredients of your subject? What are the points which you are making up in your subject? So, clear thinking, very clear thinking must be there on the basis of which you should analyze your subject. So, first, knowledge of the subject, second, clear thinking. And the third is, on the basis of these two, there must be a mental preparation before you speak. Before you speak, there must be a mental preparation. I'm telling you of one of the finest speakers in the world, Sir Winston Churchill. Previous night he used to write out, dictate his speeches. It was next morning delivered extempore. But previous night he used to go into it with a minute preparation of dictating the speeches. The mental preparation, as I'm telling you, the mental preparation, the knowledge of the subject, the clear thinking, all is there. You should also first try to, yes, somebody is asking me anything.
No, no. So I just request everyone to kindly keep their mics on mute if they're not speaking. So please.
Yes. Therefore, before there is an oral speech, there must be a mental preparation. If necessary, you can write it out. For a lawyer, it is always advisable that you first write out your argument. There you can fine tune. You find that you have since you have written out your argument. There are some areas which is verbose. There are some areas where there are repetitions. Then you can fine tune. Such a great speaker as Sir Winston Churchill used to do it. So these two stages, knowledge, clear thinking, mental preparation, and then an objective analysis of your subject. There is no point being sentimental. If you are sentimental, if you are very subjectively involved, you are emotionally charged, you tend to get carried away. You lose the art of brevity. So these are very vital inputs which I can give to young lawyers and everybody. In order to master the art of it's an art. It does not come so easily. If you practice this, you'll find today the amount of brevity which you have attained, if you go on practicing in the same way, after 6 months, your quality of brevity will improve. It is bound to improve. As you saw in any player, think of a great cricketer Sachin Tendulkar. His initial innings and his later innings, if you see, as a batsman, is far improved, referred by him. So it is a matter of constant effort, constant practice. I'll give you some examples, very handy examples. Like we use the word, it is not big. Don't use that word, use the word small. We often use the word he is not honest. Don't say that. Say he is dishonest. I mean, avoid many prepositions in your speech as far as possible. Use more verbs than adverbs and adjectives. You see, English language, the genius of English language is that it is brief and to the point. The genius of British people, they are famous for their understatement. We tend to sort of exaggerate things. You must have read that famous book by Nobel laureate Professor Amartya Sen, Argumentative Indians, where he has said Indians are very prolix. The British genius is, you see, if you find a commentary by a British commentator, you see they don't use very many adjectives. If a person plays very well, he said, yes, he has played reasonably well. We always lose our fund of adjectives, and we go on repeatedly describe a thing with flourishes. The flourishes should be cut out. It does not improve your speech. It does not make a better impression. If it is a literary effort, there also, you see, in literature also, you must have read Shakespearean sonnets. The sonnets are within 14 lines. They are creating much greater impact than the long speeches of the actors or their soliloquies. Sonnet is evolved as a form of poetry, which is only confined to 14 lines. In Indian literature, sonnet is not very much popular. Only in some of the poets like Michael Madhusudan Datta and others, they have introduced sonnets. There are very few sonnet writers in Bengali or Indian literature. But there are several sonnets in England, especially the Shakespearean sonnets are very important. So even if there is in poetry there is abundance of emotion and feelings, but even then it is within a compass of 14 lines. I'm telling you of a short story as a literary form. Sometimes a short story creates greater impact than a novel running into 1,000 pages. A short story, the Mopassa's short stories, they're masterpieces. So in India also Premchand's short stories, Tagore's short stories, they create much 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 more human impact than a novel. So the art of brevity, I'm trying to analyze the art of brevity by giving you the examples from literature. Because in literature we tend to overdo things. There's a spontaneous overflow of our feelings. Even then, now in the therefore use more verbs than adverbs. Use active verbs instead of negative verbs. Negative or use positive words all the time. Now, so far as a lawyer is concerned, you see, in our book, which is one of the most, which is the Bible for every lawyer practicing on the civil side, the Civil Procedure Code. And the Civil Procedure Code, there are clear chapters on pleading in Civil Procedure Code. Must be known, must be knowing it. How to draft your pleadings. The first thing in the Civil Procedure Code, Order 6, Rule 1 says, every pleading shall contain and contain only, these are the words, shall contain and contain only a statement in a concise form of the material facts on which the party relies. But it should not have evidence. The plaint, according to the rules of pleading, must not contain evidence. It must contain a precise statement of material facts. You must understand by your application of your intelligence, which is a material fact, which is not a material fact, which is a material fact for the purpose of establishment of your case. So pleading is precisely has to be precisely modeled on that. Of course, it has been said in cases of misrepresentation, fraud, breach of trust, willful default, undue influence, you can give particulars. Because you have to establish these things. Similarly, when it comes to the question of your filing your written statement, it is also stated in Order 8, the written statement, your denial should not be evasive. That is the language. Evasive means not structured, not pointed, not precise. The denials must be specific and precise. Otherwise, it is no denial. Otherwise, it is no denial. So the structure of your plaint and the written statement, and this applies to all civil proceedings. These basic principles applies to all civil proceedings of pleadings, and obviously the argument. And I see the same principle is carried, is mentioned in section 100, subsection 3 of the Civil Procedure Code, where it says that the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. It must precisely state the substantial question of law. So there is always an emphasis on precision, not vague, roundabout pleading. So pleading is an art. Pleading is an art. How to present your case without leaving any essential details within the short compass of brevity, which is the mandate of the law. So you must understand the principle behind this, and and automatically this is the principle which has to be carried in argument. It is not followed in our country. The bar will oppose, but in American Supreme Court, I am told specific time is allotted to a lawyer. However complicated a case may be, he has to argue, he has to give written notes of argument, and he has to argue within a specified time, normally 30 minutes for one side and 30 minutes for the other side. And these time limits, timeline are absolutely strictly maintained. This is not possible in our country. We hear arguments going on for weeks, months, judgments running into 600 pages. Now, can you tell me, courts are meant for ordinary people. Suppose my case goes to Supreme Court. Forget I am a lawyer or a judge. I am an ordinary man. They also have a right to go to court. He goes to court. He either loses or he wins. There are many situations when after winning or losing he does not know where does he stand. It has happened. Even from the, I'm sorry to say, even in respect of the judgments of the highest court, the person losing does not know where does he stand, how her rights have been decided, how his or her rights have been declared, and he again goes to court for clarification. I mean, those who know the history of Supreme Court, I can give you a reference of a case, TMA Pai's case, where the educational institution, their rights were decided. It's a judgment of, say, possibly 9 or 11 judges. And to clarify it, there are two more constitution bench was formed, Islamic Society and Inamda, to clarify a judgment of Supreme Court. So this is highly time consuming, creating confusion. You will find judgments of Supreme Court like this. There is a judgment, say, of 5 judges or 3 judges. Main judgment is delivered by, say, out of 5 judges, 4 judges delivering it. The fifth judge says, I agree, but then he goes into another 60 pages. If he agrees, it is fine. Another 60 pages will create further confusion. So that is also part of the judgment. So there is a requirement to maintain or restraint at all sphere. Only the lawyers can't be blamed. You see, the judgment is not a place to show the learning of the judge. No. Judgment means you are deciding the right of others. They are the first person in the whole system. They must know where their right stands. You cannot go on developing your jurisprudence unless you are changing the law. That happens once in a blue moon. You are repeating the same thing. So there is a requirement to maintain. That is the purpose of law, to be precise, brief, and to the point. That is the art of brevity, but it is sadly lacking. First of all, our courts are hard pressed for time. There is so much under pressure. The judge litigant ratio in India is extremely poor. Com- in that background, if the judges are given to write judgments running into thousands of pages, you see, when you during the British days, we had no Supreme Court, no constitution. We had a Privy Council. You look at the Privy Council judgments. Every year, the Privy Council judgments, the volume never ran more than 300 to 400 pages. Now, Supreme Court, 10,000 pages a year, if not more. So this is something about which everybody should be concerned. In high time, this is required for ends of justice. Our constitution is so big because we have such a diversity. And when our constitution was drafted, India is going through a tremendous period of upheaval. Those who know history, they know. We had experienced bloodshed of killing between our own countrymen on grounds of religious hatred. I'm not blaming anybody, but this is a fact. A large part of India, the native princes were trying to balkanize us. So all this diversity, India is the country which is the largest diversity in the world of race, of language, of habits, of manner of living, but still it's one India. In order to cater to this diverse culture, to the diverse tendencies, so that nobody is left out of the constitutional scope, our constitution has to be big, has to be a little voluminous. But you look at the language of the constitution, very precise. So both the constitution and the laws. And the summary of the constitution is given in the preamble. You have half a page. Half a page is the substance of the constitution, of the philosophy of the constitution, the values of the constitution. So the constitution in that sense is precise in its focus, in its essential virtues. So therefore, I think I don't know how I've been speaking for about half an hour. When speaking on brevity, I should not go further. I would advise the lawyers and my friends who are interested in public speaking to develop this art of brevity, where you must include every important point but be brief, don't be repetitive. I think I conclude whatever I've got to say. Now, if anybody wants to ask me a question, I'm open to answer.
So, thank you so much. I think when you were discussing the topic of brevity, so I believe that you are, in my humble understanding, one of the best faculties to uh, tell anyone what brevity actually means. Everything that you speak, it's very precise and always to the point. Sir, you mentioned a differentiation between verbal and written pleadings, and how brevity plays a role there. So, is it should we assume that both are exactly the same? Whatever we have pleaded verbally, whatever we have pleaded in writing, the same needs to be there in our oral arguments, or can there be deviations in civil as well as criminal law?
No, no, it can be deviation because in court, your pleading, written pleading, and your verbal argument is going to be challenged by the other side. Other side is not going to accept whatever you have said, nor is the judge going to accept whatever you have said. So you have to meet that. You have to go into slight deviation is required. And there also you have to prove your case on the principles of evidence act. There also these two definitions are important. One is relevant fact. The Evidence Act uses the word relevant facts and facts in issue. So you have to prove your argument on the basis of relevant facts, which calls for precision. Otherwise, your case is not proved. See, you have presented a case before the court on the basis of your plaint or your petition. You have argued that. But there the buck doesn't stop because the other side will challenge it, will raise his argument. You have to meet that. Or other side also has to meet your case. Therefore, you have to travel beyond what you have pleaded initially. And your argument should cover that also, that you are able to meet the other side's argument also. So there has to be some deviation. You're unmute.
So
Unmute yourself.
thank you so much. So, sir, considering how you actually took us to where brevity is mentioned in the code itself, let's say the CPC right now. So you mentioned that when we are filing any replies, so if there is any denial of any facts whatsoever have been mentioned, then they need to be specific. So does it by any mean imply that while we are filing our reply at that point of time, so this is a practical issue which I am trying to speak about right now. That most of the times the defense is still being formulated, and how in the new act, such as the Commercial Courts Act, there is a very specific time in which reply has to be filed, and most of the times I've seen that the client does not have enough material to brief his advocate with respect to the reply. Yet timelines are there and replies have to be filed. So in that manner, sir, can there be some relaxation which people may take, or should at the time of filing the reply itself, our case strategy be ready, and whatever facts we have to plead, should all of that be ready by itself?
No, commercial cases are meant to be tried quickly. That's one of the reasons for creating commercial courts. So where the timeline is given for you to give a reply, you should adhere to this. Why should the client be not ready with facts? The client knows. It is the client's lack of effort or casualness in approach which prevents them from giving you the facts. Because when a case is put up before the court and the court gives you time to deal with it, within say 2 weeks, 3 weeks, whatever it is, you should be immediately, you cannot invent facts. Facts are there. You can't invent facts. If you invent facts, they will be caught. The facts are there, you have to collect them, you have to be up and doing. You can't afford to take a casual approach. The court may refuse to give an extension. This is the discretion of court. May give one extension, but may not give you repeated extension. If the court does, then the very purpose of commercial litigation is lost.
Absolutely, sir. Thank you so much. And it's actually a fact, sir, that facts cannot be invented, and yet it's still a problem. I think you
And
mentioned.
I tell you here one thing which is also very important. Which in order to master the art of brevity, you must first master your command over the language. In this connection, if I may quote what Lord Denning said, Lord Denning said that you must be the master of your language. You must be able to play with the words in the same manner as a pianist play with his piano. The pianist notes are always very sharp and short, but sweet at the same time. Similarly, your language must be sharp and crisp. For that, you must have a command over the language. Without a command over the language, you will be beating around the bush. This is what you read Lord Denning's books. The beautiful read. And he has a look at his language, the language of Lord Denning. So crisp, so clear, so simple, but at the same so effective.
Absolutely,
Try to imbibe his style. No flourish, no rhetoric, but he's making his point.
absolutely, sir. Thank you so much. So, just one thing I want to tell all the participants that I understand that there are some questions which everyone has. I request you to kindly raise your hand, so or share your questions in the chat box. We'll take them up locally. So Abhishek ji from Bombay has a question. Abhishek ji, welcome. What's your question, sir? Please let me just permit to unmute. Yes, you can unmute now, please.
Sir, rather than going in the English, I would like to tell something in Hindi. सर आपके दर्शन हो गए, यही काफी है हमारे लिए. पॉइंट नंबर वन. पॉइंट नंबर टू, एडवोकेसी with the heart or with the brain or with both, how it should be, because the brevity depends upon on the talmel of heart and brain. So
Yes,
इसके
you're
ऊपर थोड़ी
right.
सी रोशनी सर.
Yes, you're right. Heart and brain must go together. That your brain should control your heart, especially in a matter where the court has to decide questions of legality or otherwise. Because by just your heart, you cannot decide a case. Because the court is also bound by the law. Court has normally go within the structure of law, where very little heart is there. Some heart is there in law itself. Law can't be heartless. Law can't be without any emotion. Law can't be without any compassion. But at the same time, the letters of the law have to be followed very correctly. So if you completely dilute your brain by your heart, then you lose your track. You have to make a very, very, if I may say so, very rational balance between the two. Initially, you should try to go by your brain. Wherever heart is there, you allow the heart to play its part. But you can start with your heart. You see, all forms of injustice can be remedied in court. It is because of some compassion, some element of what I may say ethics and morality of the law that the area of law has been expanded. What was the law, say, 50 years back is not the law today. The rights of the people have been expanded. That is the purpose of the court. But while pleading before the court, you must not start with your heart. You must start with your brain, and then, if necessary, you can formulate your proposition to point out the inadequacy of the law, if any, where the law is heartless, where the law is lawless. Even in order to prove that, you have to start with your brain. It's a very curious mixture of the two. You've raised a very pertinent question.
थैंक यू वेरी मच सर, थैंक यू वेरी मच. एंड कोटि कोटि प्रणाम सर, कोटि कोटि प्रणाम. थैंक यू सर.
नहीं, हमको प्रणाम करने का कोई ज़रूरत नहीं है. गिव योर प्रणाम टू द ऑलमाइटी.
The Almighty manifests through our gurus on earth, sir, and I think that is what Abhishek ji says when he says "Koti koti pranam to you, sir." तो सर एक बहुत ही अच्छी एक बात अभी अभिषेक जी ने
Uh,
कही हिंदी में बात करने
Good
के लिए.
afternoon. Good afternoon, Keshav. This is Dr. Chola Raja from Delhi
सर
University Campus Law Center.
सर
Yes,
नमस्कार चोला राजा सर प्लीज.
I want to ask a small question because many of my lordship, very good afternoon, lordship. I read about your judgment also, particularly regarding the the Ram Mandir judgment. You made the great statement that how should be the brave the error is made. That I was very great fan of you, lordship. My question is that many of my students preparing judiciary after LLB, the direct judiciary, the municipal and the DJs also. So how my students want to prepare for those judiciary with the brevity manner of the how to provide the justice, because most of them prepare for the good job. When
yes.
I'm asking my students, I ask them why you are preparing the judiciary. They say, sir, I want to get the good job. Whether it's really job or want to provide the justice with the brevity, that the brevity, how my student want to improve that lordship. Give me some guidance so I will intimate to my student.
The job of a judge is not a job alone. It's a job with a mission. It's a job with a lot of ethics involved in it. I shall give you a story. I don't know whether you've heard the story or not. A man going was walking on the road. He suddenly saw some masons working on a huge building. He asked the mason, "What are you doing?" One of them told the man, "Can't you see? I am cutting stones." The man was not happy. He asked the other man, "What are you doing?" He said, "I'm earning my living, my wages." You're still not satisfied. He went to the third man. He said, "What are you doing?" He said, look at it. We are building a cathedral. We are building a mansion. That is important. A judge has to build a cathedral of justice. He has to change the society. A judge is not a mere umpire. These are not my words. These are the words of Justice Krishna here. You've seen in the cricket field, when there is an appeal, an umpire raises his finger. He
Yes, Lord.
merely applies the rules of the game. The judge is not merely to apply the rules. He is to fashion the society. He is to take the social revolution further. He has to change the life of lots of people who are denied justice. The job of a judge is not a job alone, not merely for earning wages. There is a mission behind it. When a person stands before you for justice, you must remember there are at least 1,000 people who cannot come to court but who are suffering similar injustice. So your decision of that case should give some succor to those 1,000 people. Yeah, you are really people are looking at you only next to God.
Yes,
They
Lord.
cannot see God. They cannot reach God, but they can see a judge. They can reach a judge.
Yes, lordship.
In this world where injustice is so rampant, you have an opportunity to remedy that, to right that wrong. You have a great role. You must realize that role in society. And I'm very happy that your students are willing to join the judiciary. Good people should come.
95% of students of mine, even Keshav also my student, he also told me that I want to prepare judiciary only lordship. I'm
Yes,
very happy that he is
Sir
fighting
Chola
for
I'm
that.
Raja
very
sir
happy.
is a
Very
professor in
happy
Delhi.
that good people are coming to judiciary. We need good people.
Great, great. Thank you so much, lordship. Such a great and insightful lecture today. I was attending. I'm really very happy, lordship.
Yes, kindly pass it on to your students.
Uh, Surely, Lordship, one day we will invite you in the campus law center also, please, Lordship. After this winter, we will invite you, Lordship, in
Yes, yes,
CLC
sir. Chola
also.
Raja, sir, we have to do this, sir. We have to, we must do this.
Truly.
And absolutely, sir, as soon as possible. So it will be a
Anyway,
privilege. Ganguly, sir, hopefully you will have the time to come here to Delhi University for this session as well.
Surely, surely, yes.
give
Because
me a
no
little time
students
to
need that.
organize. Yes, yes.
So I'll coordinate, sir, absolutely. So,
Thank
sir,
you.
there are other questions as well. Chola Raja, sir, thank you so much. Uh, so there are other questions as well. Sir, before going into so just two, three questions more, I think we'll probably have time to take. But sir, one very important question I understand that needs to be asked because video will also be there for future reference for everyone. So when a person goes to a police station so I'm speaking about brevity in criminal matters. When a person goes to a police station for initiation of an FIR, they give some kind of documents. It happens in matrimonial cases as well. For anything at all that they try to give some kind of complaint. So, should that complaint be absolutely brief and very small, or should it encompass a lot of details? Like some people have good memory, they even remember what was said when. Should all of that be there, or should it be very specific?
I tell you, it has been said by Supreme Court many occasions because a FIR you must disclose the ingredient that if you are saying that this has happened, this offence has happened, the ingredient of the offence must be there, not in great details. Because the principle in FIR is it must disclose the commission of a cognizable offence. That must disclose. It cannot be vague again. You must disclose who has committed the offence against whom and how and when. These details must be there. You must say X has committed the offence against Y, how and when. These four details must be there. The Supreme Court has said that an FIR is not an encyclopedia of the case. Suppose somebody's name is not mentioned in the FIR, he can be also arrested on the basis of investigation if his complicity is surfaces. So he can also be arrested. He cannot say, I was not named, therefore I am scot free. No. He might, out of 6 persons, he might forget to name all six, he might remember fourth person. Human memory is not like a computer. I may forget, but maybe later on, other persons who have seen the incident, they may implicate. So because these things, the most important part of a criminal case is investigation. That investigation has to be done honestly, intelligently, and expeditiously by the police. You emphasizing the word expedition. Otherwise, memory is lost, evidence is lost.
Even I would like to add into this that even if the faulty or any mistakeful investigation is done, that can be cured during the course of trial also,
Very difficult. But the court also has a duty. Courts can direct re-investigation.
to bring the
Court may not
unvarnished
be,
truth before the honorable
yes,
court.
yes, court may not be satisfied with the police report. Court may direct possibly under 173(8) of the CRPC a further investigation.
Arushi case is the best example, sir. Arushi case.
Yes. But Arushi case, I was there involved in Supreme Court. When they came for quashing, I said no quashing, face the trial.
So it's just fantastic, so that this thought came up. So what is going on in the mind of a judge when some highly politicized or maybe some media sensational case comes before a judge? So what goes on in the mind of a judge?
चलो मैं आता हूँ.
What goes on in the mind is the same thing, how to do justice in the case. Just because the case is sensational from the media point of view does not mean the judge can feel relaxed in his duty. Judge has to be constantly alert, maintain an impartial image of the court, and do his duty. Judge should normally ignore these media reactions, normally, and should be above all this. Medias are trying to, that is their job, they have to sell their newspaper. Because a newspaper and this channel, they are all commercial entities. Delivering justice is not a commercial thing. That is, nobody can buy justice. You can go and buy a newspaper. You can go and buy a magazine. You can go and get a channel by paying against it. But justice is above this. You can commodify justice. Therefore, judges have to be very careful. Anything else?
Absolutely, sir. So thank you so much. Sir, there is a question from Miss Kirti Malini. Kirti Malini ji, you want to ask your question, ma'am?
Yeah, good afternoon, sir. This was a very lucid talk. I just wanted to ask, what is the reason you think that there seems to be loss of brevity? Like you were mentioning about judgments previously, it used to certain, as per you, would be the reason for this.
I request everyone else to kindly keep on mute. Sorry, sir.
Yes, yes. Please repeat your question. I couldn't hear you properly.
Sir, I just wanted to ask, what do you think, as per you, is the reason for loss of brevity in court proceedings these days as compared to previous times, sir? What is, according to you, is the solution for this, sir?
A solution for this, I can only offer it because the judges, when they're laying down the law, suppose they're breaking new grounds, then the judgment can be a little longer because they have to trace the history of the law. But when they're repeating, following the beaten track, they should not be very prolix. That's my humble suggestion. When you are following something which is the laid down law, which is the case in more than 95% of cases, so more than that, you should not be prolix. Because every word in a judgment weighs. Every word in a judgment counts. So you must economize the use of words. Well, if we are going to make new laws, as the Supreme Court does normally, in many cases, there you can break new grounds. That's my humble suggestion.
So,
Basically, you're saying, sir, that precedents should be. Is that so?
Yes, what is your question?
So I just said what you're saying is that laws are already made and precedents are there.
Yes,
Maybe.
yes. When you are following that, when you are following the beaten track, you should not be prolix. Look at
Right.
the way the judgments are delivered in Privy Council. They just say this has been laid down in such and such case. This has been laid down in such and such case. Therefore, following that, we hold this. There is a clear step of reason. And instead of that, if you say this has been held in that case, and then quote the judgment total fully into say 30 pages, it's not required. Suppose you refer to judgment X, just say that this has been held in that case, these are the principles laid down. I am following the same principle here also, in the facts of the present case also. That cuts down on the bulk of the Supreme Court reports. That can. Instead of setting out the text of the judgment whole hog, that is something which is objective. We are following the beaten track. You're following some law which is already laid down. There's no good burdening your judgment by quoting the entire law which is laid down. You look up, cull out the principles which have been laid down, and then say I'm following this principle in the facts of this case. That is my suggestion.
Thank you, sir.
So it's quite so it's actually very enriching and very important as well. So just one follow-up question with respect to Kirti ma'am's question only. So one advice for young lawyers and for law students. I am also hopefully going to give my AOR examination. So there are judgments which are more than 1,000 pages. So
Yes,
how does one read those judgments?
very difficult. You don't know where one goes into.
Hmm.
Because very difficult. That's what having been in the profession both as a lawyer and a judge for more than 50 years, at times I find myself at a loss. What is the ratio? Because the judges should be a little careful on this. And I am not thinking of myself, a person in the field of law or a law student, but for a layman, you must think of the layman.
So,
It is his rights which you are deciding.
so because it becomes really very difficult, sir. At the same time, sir, one thing which Abhishek ji in his question he raised that in Hindi. So how I see, and so this is just I'm just humbly seeking your guidance in this respect, that in states like Uttar Pradesh, in states like Madhya Pradesh, Rajasthan, where Hindi is a language of the courts, from where Abhishek ji comes, Maharashtra, where Marathi is used in the district courts. And similarly, sir, considering the diversity that you mentioned about India, so does brevity, how we discuss sonnets and the propositions or howsoever, the grammatical things that we need to keep in mind while advancing arguments or while drafting. So does the same thing apply to all languages and all court proceedings in various jurisdictions?
Every language has its own character, has its own genius. Now, say for instance, Urdu, I do not know, but I tell you from my humble experience, Urdu is not as brief as English. And as a court language, as especially a language of the high courts, I'm saying in district courts, a local language can be used. But in the high courts, normally because the high courts, in our system, we have a federal judiciary. Supreme Court, the language has to be English because there are several persons coming from different areas. And the high courts also, because the high court is equally important as the Supreme Court as a constitutional court. There also in a high court, I can go to Allahabad High Court, I can argue. I may not know Hindi that well, but if you say that you cannot argue except unless you speak in Hindi, then I am ousted. You can't do that. The High Court level, that's the reason why English has to be maintained. All the High Court judgments are written in English. Then we go on translating them. It will be impossible to give a correct translation. So therefore, the High Court level, the language should be English, which is the common connecting legal language, which has been accepted in our country for centuries. It is not disruptive. The regional languages can be there in the district court, yes. But at the High Court level and at the Supreme Court level, if you try to introduce regional languages, then it will be a huge chaos.
So thank you so much, sir. So there is a question from Miss Pridarshini Saini. Pridarshini ji, please ask your question. Pridarshini ji, are you there?
Good
So,
afternoon,
Mr.
sir.
Kashwar,
Good afternoon, yes.
So my question to you is that how does brevity play an important role in the clarity of communication in the legal proceedings?
Yes, it will, if you are brief means to the point. Brief does not mean you have to be scrappy. As I've said, brief does not mean you have to be scanty. Brief means all the points must be presented in a capsule form. That, as I have told you initially, that must proceed by clear process of thinking, objective thinking, and it depends on your ability to express them. Therefore, a mastery of the language, your clear thinking, objective thinking must precede a brief communication. Brief communication is there, which contains all the points, that it impresses the judge, impresses the listener. It becomes easier for him to decide. Other than prolix argument, which will completely bore him, and his attention will be diverted, his intelligence will be fagged out, and you may not be able to make a good impression. So brevity is very, very important in legal pleading and also in argument.
Priyadarshini ji, hopefully that answers your question.
Yes, sir. Thank you, sir.
So one last
Okay.
question, sir. Mr. Kashyap from Kashyap Law Office has a question. Kashyap ji, are you there?
Hello, hello. We're really so thankful to have Mr. Justice Ashok Ganguly online. My question is that whether a mixed question of law and facts could be raised before second appellate court, if not raised before first appellate court.
It can be, provided that particular fact which is mixed with law, is material. We have not raised it before the first appellate court. If you raise it before the second appellate court, you must take the leave of the court, and court must allow you to do that. It
So we have
depends,
to file
you
application
know,
for
yes, you know that the court has to frame the question.
questions.
A court has framed, suppose, question A, and you find the question B, which is another question which is not raised, but which is very crucial to the material. Then, for ends of justice, court can allow you to raise that question, allow the other side to answer. It can be done.
So, Kashyap ji, I hope that answers your question. So, it's truly and most humbly our biggest privilege and an honor to have this occasion to learn from you. And so it's how do I say, so it's most valuable, and I understand that. So it's just your blessings and your guidance, which I think is uh, absolutely a guiding light for all of us. And all of us, I'm absolutely certain people who've been able to attend this class today over here, and those who will be able to refer to it on YouTube later on, will absolutely and only gain from this session and every single interaction that we have with you. So I extend deepest gratitude to you on behalf of myself, our team, and every one of our participants and people who are going to uh, continue to learn from this session.
I also thank you very much for interacting with so many persons involved in the field of law. And also, it was my pleasure to sort of share my thoughts with you on the question of the art of brevity. And I'm also very happy and privileged to do that. Thank you very much.
So it's always a privilege, and so I just pray that we may have this opportunity to continue to keep hosting you, sir, and continue to keep learning from you forever and ever.
All the best for a happy new year. This is still January. I'm all wishing you all the best. Thank you.
Thank you so much, sir. That's just so kind of you. So also just one final thing. So there will be a compendium, sir, of the previous session that you had, so that we had the occasion of learning from you on orbital dictum as well. So including that, sir, season 3 of this Hon'ble initiative, so this is a free legal literacy initiative. So it has been completed, and so I'll be sharing that with you. And so with your kind blessings, also want to introduce that later on to all of our participants. So deeply grateful to you, sir.
All the best.
Wish you a wonderful
Same.
day
Thank you.
and year ahead. Thank you so much, sir. So kind of you. Thank you, everyone.
Thank you.
And so I seek your permission to end this meeting now.
Yes, thank you. So I'm leaving
Thank
the
you.
meeting. Thank you.
Deeply grateful to you.